was a lot for the judge to determine and take in this morning, as I am now joined by criminal defense attorney Jeffrey Wolf and entertainment attorney Mitra Ahuria. And Jeffrey, let's start with you here. The state is trying to prove ownership of the Snapchat account, but the defense says it's irrelevant. Where do you stand?
Well, I mean, obviously, I stand with the defense. That's where I sit most days. But what I will tell you is the reason that they're fighting all of this is because the phone in a criminal case is the whole case nowadays. And so they're going to fight tooth and nail against every piece of evidence that could make their client look bad, that could tie their client to this potential message, which is where this is all heading, where they're saying that he admits that he did it, right? That's what they promised in opening, and that's where they're headed with all of this evidence. And so that's why the phone is so important to them, is because that message was sent from this phone. That's our assumption at this point. And so what I will say is that the defense is doing the right thing. They're making the correct arguments. They're refusing to let the judge stop them from making a record on issues that he's already made up his mind on, because you do have a right to make a record in every case. But what we're really seeing here is what has to be the most frustrating part of any judge's job, is when you're sitting and looking at voluminous amounts of data in discovery, and then the prosecution is coming in and saying they should have been able to figure out which 10, 15 videos we wanted to bring in from the thousands of videos in anyone's social media account. It's frustrating for a judge to not have that issue litigated pre-trial, and I get that. And the best practice is to file these motions in limine, which are motions filed about evidentiary issues pre-trial that the judge is wishing the defense had done, and quite frankly, I do as well, because then they could have had these arguments at a time where the judge had the patience for them. The judge should always have the patience to deal with the criminal rights of a defendant in a criminal case, but they don't. And you have to know that as a defense attorney, and you have to litigate these issues pre-trial, because it is clear that if they had done that, they would be dealing with a lot less of the arguments about what the prosecution has or has not given them, what information the prosecution has or has not made available to them as far as exhibits that would come in at trial. These are pre-trial motions in limine issues. They're still appropriately brought right now, but they're most effectively brought before the trial starts. And like the judge said, a jury's waiting in the back.